But the question, and I may have the question wrong. Dr. O'Connor is asking you, since you don't have an attorney, you would not have an attorney, and there is a protective order that says he must communicate through an attorney, that he believes that the effect of that is he could have no communication at all. Did I restate that correctly, Dr. O'Connor, or?
That's correct, Your Honor. Yes.
Well, let me ask Ms. Ho this. Ms. Ho, do you understand that when you become a pro se litigant, you become your attorney, so that Dr. O'Connor would have no choice but to communicate with you like you were an attorney? Do you understand that?
I understand that, Judge, but he has attorney.
Well, he does not have an attorney today. If when we leave this courthouse in about 30 minutes or less, it's going to be Dr. O'Connor versus Ms. Ho, both being pro se litigants. So that, for example, if he has discovery that he wants to get from you, documents, those kind of things, he can email. Ordinarily, he would email your attorney. But since you're pro se, you take the place of your attorney, so that now he would have to email you saying, please produce, et cetera, et cetera, et cetera. My only question is, do you understand, until you get a new attorney, you stand in the shoes of an attorney, and Dr. O'Connor, and I apologize, Dr. O'Connor, for not calling you doctor each time, but Dr. O'Connor would not be in violation of the protective order as long as he is communicating with you about this case. Now, he can't harass you or do anything like that, but he can communicate with you like he would have communicated with Mr. Thompson. Do you understand that?
I understand, Judge, but can I say something?
Sure.
Dr. O'Connor can afford a lawyer. If he thinks that he cannot communicate with me, he can hire a lawyer. He's been having lawyers. I cannot. I would love to have a lawyer, but I cannot afford it. And if he's been talking about constitutional rights, he wants to force me to hire a lawyer when he cannot do it. He can afford a lawyer. He has lawyers, 6 or 7 lawyers already.
All right, Ms. Ho. Everyone in this state is entitled to represent themselves. I don't have the authority or power to order Dr. O'Connor to hire a lawyer, just like I don't have the power to force you to hire a lawyer. Unfortunately, in these family law cases where there is not any termination of rights, the laws and rules do not allow me to appoint lawyers to indigent litigants. So while you have the right to represent yourself, that's your right. Now, I think what Mr. O'Connor was getting at, which I can't order either, he was saying, hey, she's saying she doesn't have the money. She's got this second house, out here. She bought a new house before she sold the old one. So the old one now becomes a pot of money. She can go sell it and get money to hire a lawyer. But I can't order you to do that. He can't order you to do that. It's your house. You can do what you want to. So that's where we are. But I just wanted to make it plain, as long as Dr. O'Connor is not harassing you and is only communicating with you about the case, like giving you notice of hearings, forwarding you pleadings that he's filed, those kind of things. And he can do that. Now, once you get a lawyer, then that lawyer is going to write him a letter and say, Dr. O'Connor, I now represent Ms. Ho. All communication must come through me. Okay?
Yes, sir.
All right. Now, Dr. O'Connor, I appreciate your opposition to this, which is basically you want her to have a lawyer. Okay, but as
May I respond quick?
Sorry, well, as I just told everyone, she wants you to have a lawyer. I can't force either of you to have a lawyer. Both of you have the right, and you were talking about rights in your last motion. Both of you have the right, and I'm not going to take that away from you, have the right to represent yourself. I don't advise it. I would advise both of you to get lawyers. But like I told you before, I'm here to follow the law, and that's what I've sworn to do, and that's what I'm going to do to the best of my ability. So I'm going to grant Mr. Thompson's motion to withdraw. And I'm assuming, Mr. Thompson, in your motion, you have given notice of Miss Ho's information, so that the clerk and Dr. O'Connor will know how to get her notice of hearings, although I don't see it in your motion.
Yes, Judge, that's correct. We have included her current address for those purposes. In the order on the withdrawal, I will include both her current address as well as a appropriate email address for email notifications of service.
All right. Well, if you will prepare that order and submit it to the JEA sometime later this afternoon, then I will sign it. So I think I have taken care of all of the motions that were set for hearing today. Does anyone disagree with that? Not that you agree with my rulings, but does anybody think that there is an outstanding motion that was noticed for today that the court has not dealt with?
No,
If
Your
I
Honor.
may, Your Honor.
Somebody said if I
May
may.
I did, Your Honor.
Yes. Well, I was going to get to you, but Mr. Thompson, do you think there's anything that was noticed today that I haven't heard?
No, Judge, I think that wraps up all of our business for today.
All right. Dr. O'Connor, what's your thoughts on that?
If I could briefly just refer back to your rulings concerning the plea to the jurisdiction, just so I can clarify that. You overruled which parts again, sir?
Okay, I have denied your request for any resolution of essential pretrial questions of law. I have overruled all of the objections that you have made, and they number some, well, I've already closed that document, but all of the objections that are noted in your motion, and I have denied the plea to the jurisdiction. So I think, based on the title of your motion, that I've dealt with everything contained within the motion. And Mr. Thompson is going to draw an order reflecting my ruling, and he will email you a copy of that, and then I will sign that later today.
If I may, Your Honor,
Yes.
given your rulings, I'd like to place an objection to the denial request for pretrial motions and place an objection to your rulings concerning the objections in the pleading. If I could ask you for a ruling on my objections, Your Honor.
Well, I've already ruled, and what you my rulings on your motion. I'm not supposed to tell you how to practice law, but I'll give you a little mini deal.
Yes, sir.
My order that I'm going to sign, and you're, by virtue of not granting any relief to you in your motion, then years ago, if we were in a trial, well, we would have to, lawyers would say, well, judge, note my objection. Well, we stopped that about 40 years ago. So that if this case goes to an appeal, after it's all over, you will have a point of error that says the trial court erred in denying my request to make pretrial rulings. The trial court erred in overruling my objections contained in the motion, and the trial court erred in denying my plea to the jurisdiction. And that will be what you raise to the Third Court of Appeals in an appellate brief. So your objections are, to make you feel better, I'll say it, are duly noted. And you, in my view, you have preserved your error for appellate purposes.
So if I may, you actually don't have to say again, I'm denying your objections, or your objections are overruled any further.
I think I've already ruled that, but I will say it again. The court
Yes, sir.
is denying any requests contained in your motion for resolution of pretrial questions of law. The court is denying all of your objections that are numbered. I don't know what the numbers are. I guess I'll pull
Yes,
up
sir.
the. What day was that document filed again?
On July 6th, sir.
Okay.
37 objections, Your Honor.
Okay. So I'm overruling objections 1 through 37, and I am denying the plea to the jurisdiction.
Thank you,
Anything
Your
else?
Honor, no, sir. Thank you.
All right.
If
Thank
I,
you very much. And
if I could ask the court, I'm sorry,
yeah.
Your Honor, I
No,
forgot.
go ahead.
With all due respect, could I ask the permission of the court, since it was my motion, if I could write up the order and get it to the court and Mr. Thompson?
Judge, I have already prepared the order in the time that we've been discussing the ruling. I will circulate it
I'll
to,
pass.
All right. Well, your request to prepare the order is denied since Mr. Thompson is on it. And Mr. Thompson, to make Dr. O'Connor feel a little warm and fuzzy, you can put on his, if you've got a Word document, that he agrees as to form, but objects to the substance of the order.
understood, Judge.
Okay. Thank you very much. We didn't get to this gentleman that's got on the headphones. Was he a proposed witness or just a watcher?
Witness, Your Honor.
Okay. Well, thank you for being here, sir. We didn't need you, but we appreciate your willingness to participate if needed. So that'll be the ruling of the court, and we will stand in recess. Everyone may be excused.